Welcome to Lay Us Code to Be Honest, or Everyday Law, where we discuss the laws that affect you every day. Today we will be discussing medical malpractice claims. How are claims brought? How do you know if you have a claim? And ultimately, how are those kinds of claims resolved? We have with us two guests that will help us discuss these issues. Our first guest is Audrey Tolson. Audrey Tolson is with the Tolson Law Firm. She represents patients who have been injured by medical malpractice. Our second guest is Carol Weiner. Carol Weiner is with the law firm Allen, McCain, and O'Mahony. She concentrates her practice on the defense of doctors and physicians. Thank you both for joining us today.
Thank you, Charlotte.
Thank you for letting us be here.
All right, before we begin, let's actually discuss and talk about how would you even know whether or not you have a medical malpractice claim? I mean, simply because you go to the doctor and something goes wrong, does that mean that you automatically have a medical malpractice claim, or how does that work? Audrey, let's go ahead and start with you.
Well, not necessarily. Just because something bad happens in the care of a physician or a nurse or a hospital doesn't necessarily mean that there's a claim there. But what I like to tell clients is that there's a kind of a gut check that you need to go through. If you have a feeling that something didn't go the way it should have gone, then that's the time you need to seek counsel.
Okay. When we talk about seeking counsel, do you simply automatically call an attorney? Do you talk to your physician? What would really be the first steps that someone would take if they have this gut feeling that perhaps there's been an error or something has gone wrong?
You should talk to an attorney, preferably one that specializes in medical malpractice, simply because they've seen enough of those cases so that they can get a feel early on whether or not there's actually a claim there. And that attorney will take you through the steps of figuring out whether or not the doctor did something that he should not have done, or didn't do something that he should have done, or it was just simply one of those things that happen. Because sometimes that is the case when there are medical issues that arise. There are complications that occur that's really nobody's fault.
Okay. What would be the first thing, let's say they come to someone like you who specializes in medical malpractice claims, what would be the first step? You have, let's say, a feel that this is potentially a claim, you don't know for sure. What is the first step that is undertaken to really assess the case and determine whether or not there is an actual claim?
Well, the first thing I like to do is sit down and talk to the person, or if the person that it happened to is deceased, I sit down and talk to their loved ones, whoever has the most information, and I get the details and kind of go through them. What occurred, what went wrong, you know, why do you think it went wrong? Has anyone said anything to you to lead you to believe that something happened that shouldn't have happened? And once I go through that step, I can kind of tell early on whether or not it warrants getting the medical records. And if that is the case, then we go through, we order the medical records, and we review them in our office, and we also enlist the help of medical professionals to also review those medical records to help us determine whether or not there is something that's called a breach of the standard of care, or meaning that the doctor or healthcare professional did something that they should not have done, or if there was something that they should have addressed that would have made the outcome different that they didn't address.
Okay. Kara, let me ask you now, you typically defend physicians and doctors that have been sued in a medical malpractice claim. When would be the first time that you or your doctors would be put on notice that there's a potential claim?
It kind of depends. Sometimes the patient plaintiff has expressed frustration to the doctor, has told the doctor that they think something's wrong, or if it occurred in a hospital, told a nurse that they think that malpractice has been committed. So sometimes there's been a verbalization that the patient thinks something went wrong. But also when Audrey or someone like Audrey requests medical records from a doctor's office, that's a good way for the doctor or the hospital to know that an attorney is looking into something that happened, and give them a heads up that there may be a potential claim.
Now, if a doctor, let's say there's been a verbalization from a patient and then also a request from a plaintiff's attorney for the medical records is made, does the doctor contact an attorney, or what is the process then that happens from the doctor's perspective?
Depending on whether or not the doctor has medical malpractice insurance, usually the first thing we tell doctors to do is contact their medical malpractice insurance to let them know that there's a potential claim. Okay. If it happened at a hospital, we also like to let the risk management, the hospital know. and then go through those processes, and which will hopefully lead to them getting an attorney.
Okay. And at that point, would someone like you be contacted as the attorney for the doctor and the insurance company?
Yes, exactly. Okay. People who specialize in defending medical malpractice cases will be contacted.
And do you all do a full investigation at this point, or do you wait to see what happens on the plaintiff side?
It sort of depends, but we like to stay ahead of the plaintiff. When, when we know that there's something coming down the pipeline, we like to investigate. We like to review the records ourselves, send the records out for review to another physician to take a look at it, an independent physician. So we like to try to stay ahead of the other side if we can.
Okay. All right, Audrey, let's go back to you at this point. Let's say that you've had your medical professional take a look at the records. They've looked at it. In their opinion, it appears that perhaps something has gone awry. Either the doctor didn't follow the standard of care, the proper procedures, or maybe something was missed, a diagnosis was missed at an earlier stage, and now the issue has continued and has gotten to a worser degree. What is the next step? So you've investigated it, it looks like there's something. What happens next? Does a lawsuit automatically get filed, or how is the process?
Well, it can vary. Generally speaking, you go ahead and you get that medical professional to sign an affidavit, which is a sworn statement that outlines what they think happened in this case that was wrong. And you attach that document to the lawsuit, and that's a rule in most states currently. It provides a safeguard so that there aren't a lot of frivolous malpractice cases filed, because there's an extra hurdle that you have to go over. You have to get someone in the medical profession. In most states, it has to be someone who has that same level of experience or the same area of practice to sign a sworn statement saying, hey, this happened wrong, this shouldn't have happened, and this led to whatever harm the person has come to.
So let me interrupt you right there. So what you're saying is just because you have someone take a look at the records, you can't simply file the lawsuit. You have to have another doctor or a physician or someone who practices in that particular area affirm that in fact they believe there's been a malpractice error committed?
That's correct. That's correct. And I think it's a safeguard that benefits both sides. It keeps people like Kara's clients from being sued unnecessarily a lot of times. And it also gives me a tool to use with people who've had something bad happen to them. And if I go to a medical professional and they look at it and say, you know what, this happened and it's bad, but you know, it was well within the standard of care. They handled this the way it should have been handled. It was just a bad outcome. That gives my clients a peace of mind rather than me just telling them, well, I don't think you have a case, it can't go forward. Okay. And so I think it's helpful for both sides.
Okay. So, Kara, once a lawsuit gets filed and there has been a medical professional who has given an affidavit, who is in that particular area of practice, who knows these kinds of procedures and so forth, what kinds of defenses are the typical kinds of defenses that doctors may have to, you know, a claim for medical malpractice? Or are there common defenses?
There are. In order for a plaintiff to succeed in a medical malpractice case, that plaintiff has to prove that there, one, was medical negligence, and that negligence led to certain damages. And so, from our perspective, you know, it's easy to criticize a physician at the end of a case when you know the outcome and you know that there may have been an injury. But in Georgia and in all states, you have to look at it from the knowledge that the physician had at the time. So you have to look at it in real time, and were the decisions that the physician was making in real time reasonable decisions? And so usually a defense is, in hindsight, a physician may wish he or she had done something different, but at the time they were working on the case, they were making very reasonable decisions.
Okay. All right. Audrey, let's assume that the case has started and the injuries are the kinds of injuries that are requiring follow-up treatment. Can the patient, and who is now the client in a medical malpractice claim, continue to go to that doctor for treatment? Is that allowed? Is it okay? Is it advisable? What are your thoughts?
It's allowed, but it's not advisable. And the reason I feel like it's not advisable is because if you're looking at the cases from the perspective of what a potential juror would see, and that's kind of how we always try to look at these cases. If I'm sitting on a jury and you've sued a doctor and then you tell me that you've continued to see this doctor, then I'm going to question whether or not this doctor ever did anything wrong to you, whether you actually believed it, or whether you're just actually filing a lawsuit. And also, just from a human nature perspective, once something happens to you in the hands of a medical professional, you lose confidence in that person. So I don't think it's good for the person to continue to seek treatment from that particular professional, because they're always going to question the care that they're getting, and that's not going to be helpful in their treatment.
All right. I think right now we'll go ahead and take a break, and we'll be back in a few moments with more on medical negligence and professional claims. Thank you.
Desde el momento en que ellos llegan a nuestras vidas, dan su primer paso, aprenden a andar en bicicleta. Hasta la preparación de su primer día del 5º grado, es un reto para todos los padres criar un hijo saludable. Permítanos guiarle a través de un embarazo seguro y feliz. Aprenda sobre salud, nutrición e información educativa relacionada con el desarrollo de su hijo. Padres e Hijos Atlanta, una publicación del mundo hispánico. Recoja su copia gratis hoy. ¿Cuál es su tesoro más preciado?
Welcome back to Leyes Cotidianas. Today we're talking about medical malpractice lawsuits, and we have with us two guests, Audrey Tolson as well as Carol Weiner. Both of them specialize in medical malpractice claims. We left off at the break where we discussed whether or not it was appropriate for a physician to continue to treat a patient once a claim for medical malpractice has been made. And Audrey said that from the jury's perspective, there could be some concern that once you're treating or you're believing that the doctor has committed an error, it seems inconsistent to continue to trust them to treat you in the future. Kara, from your perspective in defending doctors, what is the belief or concerns that doctors might have in continuing to treat a patient who has now brought a claim against them for medical malpractice?
We get this question from physicians a lot. They say, I'm being sued, but the patient has made an appointment with me. What do I do? Mm-hmm. And like Audrey was saying, it does weigh on a jury's mind. It confuses them if a patient is alleging that there's malpractice and yet continuing to see that physician. And so we say, if you are comfortable seeing the patient, and if you think you can still provide good care to the patient, it's okay by us in general to continue to treat the patient, because we do think that will undermine the patient's case in front of a jury. But if the physician doesn't feel like he can give good care, or isn't comfortable, or is afraid of more malpractice suits from the patient, then we will tell the physician that he's allowed to terminate the relationship. But physicians have a process they have to undertake to terminate a patient-physician relationship.
They can't just say, we're not going to treat you, or refuse to have them come?
Exactly.
Okay.
You can't just have a patient in your waiting room and come out and say, I'm not going to see you anymore.
Okay.
It varies from state to state, but generally the physician needs to tell the patient in writing that he's no longer going to see him or her, give some other options of different physicians that patient can see, and give a little bit of time, so if there's an emergency or a problem that's come up, that patient can come back to the physician so that patient is not abandoned.
Just out of curiosity, let's assume for the sake of argument that you have a doctor who is the treating doctor and who has a claim that's been made against him, but the doctor no longer wishes to see that patient. When the doctor makes a referral to other doctors, does the doctor put the new referral doctor on notice that a medical malpractice claim has been made, or not? How does that process work?
Not generally. What we usually recommend is for the physician to tell the patient a list of potential other treating physicians and let the patient take it from there, because the physician doesn't want to interfere in another physician-patient relationship.
I see. Okay. All right. Audrey, let me turn it back to you. With regard to bringing a medical malpractice claim, we talked about that you need to have a medical professional review it, and once the medical professional has determined that there has been a breach of the standard of care and is willing to give the sworn statement or the affidavit you discussed, Are there other factors that would play into deciding whether or not it makes sense to bring a medical malpractice claim, and then what would those factors be?
Well, I think Kara mentioned it before. There has to be something called causation, and that's just a big word for saying that you have to be able to prove that what we believe is the negligent care led to the harm. That's just kind of connecting the two together. And once you get to the harm piece, just for practical purposes, for medical malpractice cases, because they can be so expensive to litigate, there needs to be a substantial amount of harm or death. The medical malpractice cases are very, very expensive. And that's one of the things that also safeguards both sides in bringing them. The affidavit that we talked about can cost several $1,000s for a doctor to sign off on, depending on the doctor's specialty. Expert witnesses, those doctors that sign those affidavits, can charge anywhere from a few $100s to over $1,000 an hour for their time. So we have to get the affidavits. Sometimes you need affidavits from more than one doctor. Once you get the lawsuit filed, there are depositions, there are, other issues that just are really costly to get it to trial, and then there's the trial cost itself. So there has to be a substantial enough injury so that it makes sense to bring the claim, because you don't want to get in a situation where you're litigating a claim that is going to cost you more to litigate than you could ever get back in the end from a jury or from a settlement.
Well, let me ask you this. Given the substantial costs that are involved, thousands and thousands and thousands of dollars just to initiate the lawsuit, and then certainly costs as it goes along, if someone has been injured in a medical procedure, it may very well be that they're unable to work, they're permanently disabled. How would someone even go about paying for a litigation of this nature that would be so costly, or would they just simply not be able to pursue the claim?
Well, that's a question that a lot of people ask when they're seeking this kind of counsel. Most attorneys that handle medical malpractice cases do so on a contingency basis. That means that you don't pay your lawyer unless and until your lawyer makes a recovery for you, and then your lawyer gets paid out of that recovery. Also, most medical malpractice lawyers will also handle the cost for you going through the case, meaning they will pay for the experts, they will pay for the depositions, they will pay for the reviews on your case, and you also reimburse them when you get a result in the case, whether through settlement or through trial. And if you don't get that result, then you don't owe your attorney any money back for the case. So the attorney has to be very careful in which case he or she chooses to bring, because they're so expensive, but the client then gets the opportunity to get good quality legal representation that they may not be able to afford otherwise.
Okay. And on the defense side, obviously there's no contingency component, because you wouldn't be recovering any money for someone. How does that work on the defense side?
Well, it depends on whether or not the physician has malpractice insurance.
Okay.
But like car insurance, if you get in a car accident, your insurance company will pay for an attorney to represent you. So in a professional malpractice case, the physician will typically put his insurance carrier on notice that there's a claim, and the insurance company will provide representation on behalf of the doctor.
Now, are doctors required to have medical malpractice insurance to practice or to maintain their license?
It depends. It varies from state to state, but not all states require physicians to have malpractice insurance.
Okay. Now, when a doctor practices, I assume they have the ability or certain privileges at hospitals. Do hospitals require that the doctors that are treating in their hospitals have insurance, or does it depend as well?
It also depends on which hospital.
Okay. All right. Let's talk about now issues with regard to licensing. And Kara, let me ask you this question. With a doctor's medical license, how does the filing of a medical malpractice claim affect the doctor's license, or does it affect their license at all?
Filing a medical malpractice claim against a physician forever affects the physician. Even if it's filed on Monday and dismissed on Tuesday, that physician from that point forward will always have to say, I was a named defendant, I was sued in a medical malpractice case. So when that happens, every time the physician tries to get medical malpractice insurance or tries to practice at a hospital, like you mentioned privileges, he will have to say, I was sued, whether or not the case has any merit. At that point, the physician's license is not at risk merely from having been sued. But if a case is settled on behalf of a physician, there's a data bank, and the person who pays the amount, the insurance company, is required by law to report that physician to this national practitioner's data bank. And that data bank is queried by hospitals and by malpractice insurance. And so if a physician is trying to work at a hospital and he has had a settlement, then that will come back to the hospital, and that will say, you know, Dr. Jones had a settlement and X amount of dollars, and that can affect whether he can practice at that hospital.
Okay.
And as well, oftentimes that's reported to the physician state licensing board, which then could take some action.
Okay. So it sounds like if there's an ultimate resolution or a settlement of a claim, then that is the kind of thing that someone could find out at some point down the road. That's public, at least maybe not the names, but the fact of that there's been a settlement. Is that right?
It can. The National Practitioner Data Bank itself is not available to the public.
Okay.
But certain medical boards, depending on the state that you're in, do put the amount of settlements on their websites and on the physician's profile. So some of that information does become public.
Okay. All right. With regard to their license, would a doctor have their license potentially pulled just because they have settled a medical malpractice claim, or if the claim has gone all the way through to a trial and a jury verdict and there's a verdict against the doctor, for example, would their license be pulled?
Generally, one malpractice claim or one jury verdict against a physician is not going to be the type of thing that a medical board takes a physician's license away. Medical boards have a lot of leeway in the steps that they can take. They can put a physician on probation, they could take no action, they could require a physician to attend extra continuing medical education classes. Generally, pulling a license is a pretty radical step that only occurs in very few cases, and usually only with very egregious behavior.
Okay, all right. It seems to me that there is a lot of discussion with folks that have a potential claim as to just being generally frustrated that their physician seems not to care ultimately what happened, and that they have a poor bedside manner, that they are genuinely unconcerned about ultimately what has happened to them, and they aren't sorry at all. Is there anything that that you see with clients that come to you that have that concern, that maybe they have a case or they don't? How do you counsel them in that regard?
Well, I think from my perspective, I see a lot of cases where people want to know that there is some validation that someone cared about what happened to them, that they are sorry about what happened, that they're concerned about their well-being, and that they're just not disregarded. A lot of people call me because they're just upset because no one addressed the issue at all. They've just felt that they've been left out in the cold. And I think if physicians would address the issues directly with their patients, there would be a lot less lawsuits. Even people who have lawsuits that are of merit, they may love their doctor and feel like, well, as soon as something bad went wrong, he just left me, left me alone and didn't explain it to me. And if they would take that extra step and not worry about feeling as if they're admitting to something and just say, you know what, this went wrong. Let's see if we can fix it this way, and let me walk through how we can address this, versus having an error happen and then just leave the person out in the cold. I think you have a lot less malpractice suits because of that.
All right. Well, thank you both for joining us. We very much appreciate it. I think we have a much better understanding of medical malpractice claims and how they evolve, and hopefully if you have one, go ahead and seek counsel to determine whether or not you've got a claim. Thank you very much for joining us, and we appreciate it. Join us on the next Leyes Cotidianas.
Leyes Cotidianas les llega a ustedes gracias al generoso apoyo financiero de la Fundación de Justicia Civil del Estado de Georgia. Mundo Hispánico, El vocero de la comunidad hispana desde 1979. La estación transmisora WPBA no tiene licencia para practicar leyes en el estado de Georgia. WPBA y los patrocinadores de este programa no son responsables por las opiniones expresadas ni la información proporcionada por los abogados en este programa. Este programa se ofrece como un servicio público. El objetivo de este programa es de informar y educar y no de proveer consejo legal. Si usted necesita consejo legal, favor de consultar a un abogado.